Good evening and welcome to Arizona Illustrated for Monday, June 25th, 2012. People from all sides of the political spectrum are reacting to a long-awaited decision from the U.S. Supreme Court regarding Arizona's controversial law to try to fight illegal immigration, which is commonly known as Senate Bill 1070. Arizona Public Media's Michael Chihak joins us now with the details and reaction. Michael, it was a split decision today. How did it go?
A 5-3 decision upholding one part of the law and striking down three other parts. The part that was upheld, Tony, is the most controversial and proponents say the most important part of the law, and that's the stop and check aspect that allows law enforcement officers with reasonable cause to stop people and ask them their immigration status.
Okay, and so is anybody saying that they won today, or how are the politicians lining up as a result of this decision?
Everybody's claiming victory, but they're also claiming some disappointments on both sides of the aisle, really, in this. Governor Jan Brewer, who's been a big proponent of the law, signed it into law 2 years ago, was one of those claiming victory, and here's what she had to say.
Today is a day when the key components of our efforts to protect the citizens of Arizona, to take up the fight against illegal immigration in a balanced and constitutional way, has unanimously been vindicated by the highest court in the land. The heart of Senate Bill 1070 has been proven to be constitutional. Arizona's and every other state's inherent authority to protect and defend its people has been upheld. As I have said, this is the day that we have been waiting for. And make no mistake, Arizona is ready. We know the eyes of the world will be upon us. We know the critics will be watching and waiting, hoping for another opportunity to continue their legal assault against our state.
And of course, I would imagine that a lot of people in very different sectors are reacting. What are other people saying, Michael Chihak?
Well, there was a press conference and rally in downtown Tucson today by opponents of the law, and our Andrea Kelly from Arizona Public Media was there to cover it, and here's what she got.
Today's a historic moment for all of us. All of us know what happened today. Most of us are not surprised at the decision today. But those of us in the community know full well what today's decision means. Today's decision means that the Supreme Court of this land has agreed that racial profiling can be the #1 law enforcement issue. Make no mistake about it, not including it as a crime does not prohibit police officers from engaging in the practice of immigration enforcement.
Congressman Raul Grijalva, a Tucson Democrat, has been a key opponent and very vocal opponent of SB 1070. He spoke to us today from Washington, D.C.
My reaction is a mixed one. I thought the parts that the Supreme Court struck down as unconstitutional and preempted by the Constitution were important. For no other reason than to say that this immigration reform is a national, federal responsibility, and that Congress was admonished by the court to do its job and do its job responsibly. And then the obvious disappointment about the wrong-headed decision having to do with Section 2B, because if the other three parts were unconstitutional, then certainly the delegation of federal enforcement and immigration shouldn't have been extended to local communities, local police agencies. I think that section, as a national precedent, and if applied, could set the stage for many civil rights violations.
So, Michael, what about the law enforcement officials? How are they responding to the so-called stop and check part of the Senate Bill 1070? It was upheld by the U.S. Supreme Court.
NPR affiliate reporter Michel Marisco was on the border today, and he talked to two border sheriffs, and here's what they told him.
Two of Arizona's border sheriffs had two very different reactions to the Supreme Court's decision Monday. Cochise County Sheriff Larry Deaver was mostly satisfied with the court's decision.
I consider it a win, but not a victory. The most salient and important part of the bill they upheld, and that's 2B, which authorizes state and local law enforcement to inquire as to immigration status of people that they have contact with for some other reason.
Santa Cruz County Sheriff Tony Estrada said he is frustrated by that same particular ruling.
Well, I was kind of hoping that the Supreme Court would decide that it would be unconstitutional for local police to question people on their immigration status. I was kind of hoping that they would find that unconstitutional.
Both men said the broader impacts of the court's decision will affect the interior of the state, not so much the border region. In Nogales, I'm Michel Marisco.
And of course, we also have some sound from Roberto Villaseñor, the Tucson police chief. What has he been saying about this topic in the past, Michael?
He's really concerned about the law enforcement aspects of it, and we'll actually talk to Roberto later in the program.
So the politicians are already aligning themselves or positioning themselves in certain ways depending on how they felt about this. What is next with this?
What's next is that the state is already starting to regenerate the training it needs to do for law enforcement officers to make sure that they implement the limits on racial profiling that are allowed only under the U.S. and state constitutions. Now, that, of course, is subject to challenge by individual civil rights groups. And we have one of those challenges already in the works, and we'll hear a little more about that later in the program as well.
All right, Michael Chihak, thank you very much for joining us, and we will see you again in this show because you have spoken to other people as well. Thank you very much.
You're welcome.
Now we have legal analysis about the Supreme Court decision. For that, we are joined by Carissa Byrne-Hessek. She is a professor of law at Arizona State University. Professor, thank you very much for joining us.
My pleasure.
So if we could just get your initial reaction to this very important day in this U.S. Supreme Court.
Well, it was a split decision, right? Some portions of the injunction were upheld, other were reversed. I thought that would happen. I was a little surprised that the warrantless arrest provision, that the injunction was upheld for that. But otherwise, I think sort of a modest opinion, not too surprising.
Okay, so let's go ahead and go over the four highlights here. We have 3 points that were struck down and one that was upheld. If you could just guide us through the process here as to the 3 that were struck down and the one that was upheld.
So as you remember, Judge Bolton here from Arizona, she enjoined 4 pieces of the legislation. A piece involving warrantless arrests, a piece involving penalties for people who are looking for employment, and a piece involving registration requirements. That piece basically created a new Arizona state crime for failing to comply with federal laws. All 3 of those pieces of the injunction were upheld. The court said it was acceptable and appropriate for District Judge Bolton to have enjoined those parts of it. The part of the injunction that was reversed was the part dealing with reasonable suspicion inquiries into someone's immigration status during stops and arrests.
So we heard Governor Brewer today talking about how the state will not accept, quote, racial profiling. How do you think officers are going to be able to go ahead and do their jobs, and what is it going to be based on if they do make a stop with somebody whose, quote, immigration status is questionable?
Well, I think the really important thing to keep in mind is even though a lot of people say that SB 1070 isn't or doesn't allow for racial profiling, that's not precisely true. The law says that officers can't consider race except to the extent allowed by the United States Constitution and the Arizona State Constitution. And there are court decisions from the U.S. Supreme Court and the Arizona State Supreme Court that say race can play a factor when it comes to immigration decisions. So the idea that race is somehow off the table because of the way SB 1070 was written isn't correct. That doesn't completely answer your question about what officers are going to do. I think it's going to depend on how they're trained, what precisely they're told they need to do to enforce this law. I think that this section of the law, I always thought it was a little bit strange because it's telling officers that they have to do something if they have reasonable suspicion. Reasonable suspicion, in my mind, I've never seen anything that requires people to do something or requires law enforcement officers to do something when they have reasonable suspicion. That instead is usually a standard that allows them to do something in their discretion. So I think their training, what they're told to do, may have a really big role in how Arizona's SB 1070 gets enforced on the ground.
And it seems to me that legally speaking, at least based on the number of people that we've spoken to about this topic, this is the one point that is highly controversial and the one that many people might say they will take to court if, for example, they are stopped, and it could be a third-generation Mexican-American is asked to show or to prove their citizenship in this country.
Yeah, I know that politically everyone has said that this is the key provision, this is the most important provision, but as a legal matter, I don't think that this provision of SB 1070 was really doing all that much, right? If you remember, officers always had the ability to stop people and ask about their immigration status, or to ask about people's immigration status, rather, when they were stopped. All SB 1070 did was make it mandatory. So right there, in terms of practical legal effect, it's much smaller than, say, the provisions involving employment, the provision involving registration documents, and in fact, the court's decisions in those areas from a legal perspective, I think are much more important.
And Professor Carissa Byrne-Hessig, what about the breakdown of the U.S. Supreme Court? Who decided what today?
Interesting breakdown. You had Justice Kennedy writing for the majority, joined by those people who are normally categorized as more liberal justices, Justice Sotomayor, Justice Ginsburg, Justice Breyer. And then Chief Justice Roberts actually joined with them to make a 5-person majority. The 3 justices in dissent, Justice Scalia, Justice Thomas, and Justice Alito, all dissented on very different grounds, wrote very different opinions, didn't join each other's opinions, and Justice Kagan was recused because she was a high official, the Solicitor General, in the Obama DOJ when this case was first filed. So she was recused. She didn't take part.
So how important do you think this decision is as we look across the country? Other states are considering or have considered legislation similar to Arizona's. Do you think this is going to have an impact on every state in the union, or at least a sizable amount of them?
Well, because the court wrote its opinion in a relatively narrow way, its rulings about registration laws were really limited to registration laws. Its ruling about employee sanctions were really limited to employment laws. It's going to depend on how closely related the other states' legislation is to Arizona's. This wasn't a broad, sweeping opinion that sets up the relationship between the federal government and the state government sort of in perpetuity when it comes to immigration. But to the extent that states passed laws that were truly similar to Arizona, this provides them with a lot of guidance.
Okay, well, thank you very much for joining us, Carissa Byrne-Hessig, a professor of law at Arizona State University in Phoenix, of course. This is something that we will all continue to pay very close attention to here, not only in Arizona, but throughout the country. Thank you so much.
My pleasure.
While we have been hearing from many Latino organizations about their opposition to SB 1070, not all Hispanics are against the law. In fact, some support it. Next, Michael Chihak has an interview with a member of the Arizona Latino Republican Association.
Jose Borajera, Communications Director for the Association, thanks for being with me.
Oh, you're quite welcome. I'm happy to be here.
Please give me your reaction to today's Supreme Court ruling in the Arizona immigration case.
We are actually quite pleased with the ruling because the main portion of the law, the one that was really most contentious, was the one about whether the state, such as Arizona, has the right to help the federal government with the implementation of immigration law, and that part was upheld.
Now, are you disappointed or surprised that the court struck down the other 3 aspects that were before it in connection with the law?
Actually, I was a little disappointed, but not that surprised because some of them were quite questionable, especially the one about holding somebody without a warrant and that sort of thing. But overall, the 3 points that were not upheld were not nearly as important as the one that was upheld. If you look at the whole thing in perspective, there were 13 sections to this law. 2 of those sections one was just the introduction and the other one was just naming. So there were 11 substantive sections, and they had approximately somewhere in the neighborhood of 30 to 40 provisions. Out of those 30 or 40 provisions, 4 were challenged by the federal government with the idea that they would all be stricken down by the Supreme Court, and only 3 were stricken down. So, they're talking about 3 out of 4. We're talking more like 3 out of 30 or 40 provisions in this law.
So what was the organization's stance, your organization's stance on this from the beginning? Were you in favor of every aspect of this law?
We were in favor of the law overall, yes, correct. We were very much in favor of it.
Now, based on the one part that was upheld, the stop and check or check your papers part that was upheld today by the Supreme Court, the legal challenges are expected to begin pretty soon. What is your position on those challenges?
Well, I hope that they be invalidated because we have had this request for papers all along for citizens, not citizens, everybody else. Somebody gets stopped by a traffic cop. You got to show license. You got to show proof of insurance. You have to show the registration. You have to. So the fact that somebody asks you for those things is no big deal. Now, they cannot ask for any kind of immigration status unless there's reasonable suspicion. And reasonable suspicion, I would imagine, I'm not a lawyer, but I would imagine is something like you don't have a driver's license or something of that nature, then it would arise suspicion with the officer. But beyond that, I don't see anything wrong with asking somebody for identification and this sort of thing.
No concern on your part about racial profiling, about Latinos being stopped because of their appearance in connection with this?
Well, that is strictly prohibited within the law itself. There's in about 3 different parts of the bill. And by the way, I don't think most people have actually read the bill who would render an opinion on this. People out in the street, I don't think they have read it. I have read the bill, and there's about 3 places in the bill where it says specifically that race will not be a determining factor in arising the suspicion of the officer.
So then, as a Latino yourself, you are not troubled by that part of the law. You feel protected under Arizona law in that regard.
Not only Arizona law, but it also respects the federal laws and the Fourth and the Fifth Amendment. They're all protected under this. I don't have any fear at all.
And do you see any efforts in Arizona by the Republican majority in the legislature to try to redo parts of the law that were struck down so that it might pass constitutional muster?
I don't have an insight on the legislature. I wish I would. But personally, no, I don't see any further effort along these lines. We're not going to have that much of a majority come next session. So it's unlikely that something this controversial will be taken up. Not very likely.
We only have about a half minute remaining. And in that time, Mr. Borrajero, please tell me, what's the ultimate solution to our immigration issue?
The ultimate solution is very simply 2 steps. Very simple. Number 1, you have to stop the bleeding. You have to secure that border and secure illegal immigration coming into the country. Once you've done that, then you can deal with the people who are already here. And very important that we do modify the way that immigration is handled so that those people who want to come in, who have a good reason to come in, can do so legally and don't have to wait 5-10 years to get a clearance.
Jose Borrajero, Communications Director for the Arizona Latino Republican Association, thanks for speaking with me.
Oh, you're quite welcome. Thank you.
Even though the Supreme Court overturned most parts of SB 1070, as we have said, a highly controversial portion is being upheld. It requires police agencies to check the immigration status of people they suspect are in the country illegally. Still, some members of the law enforcement community have been outspoken against this provision. Here is Roberto Villaseñor, the chief of police for the city of Tucson.
This was the provision that caused us the most concern, and it's 2 elements of the provision. It takes away officer discretion in scenarios where they have legal contact with individuals, they develop reasonable suspicion to believe they're in the country illegally, and now this law requires follow-up on that, whereas before, a lot of times officers would follow up on that. We would contact Border Patrol or ICE, depending on the jurisdiction you're at. But now it takes the discretion away.
And what does that mean to your department?
Well, it's going to stretch our resources at a time when we can afford it the least. We're already about 130 or 140 officers down from where we were in 2008. We are having a crime rate that the violent crime is starting to go up slightly. Our calls for service are going up slightly. And now we're going to take resources that we need to deal with those issues away from local safety concerns and deal with immigration issues. What the Supreme Court did is they struck down 3 of the 4 provisions. On the 4th one, they said that this one should not have been enjoined, and they sent it back to Judge Bolton to deal with the injunction. So we are going to wait for Judge Bolton to deal with that injunction and give guidance as to what that actually means, when the enforcement date takes effect, and then we will enforce that law after that. The part that was upheld is that when an officer stops someone in a contact, and they have reasonable suspicion, they're required to look into it. The other part of that statute that was upheld was that in every situation of a criminal arrest, officers are mandated to verify immigration status prior to release. So in Tucson alone, there's 36,000 times a year that we arrest people where we give them a citation and allow them to leave the scene. That could be a shoplifting arrest, a disorderly conduct, a suspended driver's license, speed greater than 21 miles an hour, DUI arrests, a variety of different events. With the provision that was upheld, the way the law is written now, we are supposed to call a Border Patrol agent, an ICE agent, or 287G officer, and those are the only three acceptable means where we can then release a person after they verify their status.
Now we hear from Dan Pacoda, the legal director of the American Civil Liberties Union of Arizona, about some of the possible courses of action from this group. Michael Chihak spoke to him ahead of today's decision.
What is the ACLU's position on SB 1070?
Well, the ACLU, of course, has been consistently opposed to 1070. Initially, we put in significant time while it was still in the legislative stage, trying to convince the folks in that branch of government of the great problems and inequities that would come about because of 1070. It was ill-conceived. It is ill-conceived. It had been tried piecemeal in years before when Governor Napolitano was still here and did not get through. And, of course, when Governor Brewer came in, there was no roadblock to getting the bill through as sponsored by Russell Pierce.
And once it became law, you filed a very early challenge to it, pretty comprehensive as you've described it. Tell us a little bit about that.
Yes, we believe and feel strongly that the law is unconstitutional in any number of ways. We, and when I say we, the lead organizations are the ACLU, the National Immigration Law Center, and MALDEF, with quite a number of other organizations, legal organizations, Asian Pacific Organization, and others involved in the litigation, and quite a number of plaintiffs. We feel strongly that the law is clearly unconstitutional in any number of ways, preemption being one of them, but we have raised a significant array of constitutional issues that go beyond the Department of Justice's litigation, which is only based on preemption, and we will be litigating to the fullest all of those issues if any aspect of the law goes back into effect as a result of the Supreme Court's decision.
And preemption being the federal versus state issue, it's federal authority here versus state authority, correct?
Correct. It has to do with the conflict between the sovereign state versus the sovereign federal government. Our position as the DOJ's position was the federal government is that its immigration is uniquely a federal prerogative. In many cases have said so. We believe Judge Bolton was correct in ruling that the key provisions of the 1070 law were preempted by the federal government and should not be subject to state regulation. We should not have 50 states and a patchwork of regulation in this important national area. And we raised that as well in our lawsuit, as well as I said, the other constitutional issues.
And let's start with those other constitutional issues. First of all, you've raised First Amendment issues.
Right. We believe that a number of the provisions of 1070 raise important First Amendment issues concerning speech and expression and rights of association. And in fact, the only provision that has been enjoined separate from the Department of Justice lawsuit is one concerning one of the solicitation provisions in 1070, which Judge Bolton, based on our plaintiffs in the Friendly House case, as the lead plaintiff in our case, raised and said it chilled speech and was unconstitutional. It was a content-based discrimination based on a viewpoint and a particular type of speech, i.e. solicitation for work. The court agreed with us, and so a portion of the law has been enjoined separate from the preemption decisions, and that decision by Judge Bolton is not up in front of the Supreme Court, so that particular provision of the 1070 will remain enjoined no matter what the Supreme Court does.
And then there are a couple of other amendments to the Constitution, the 4th and the 14th Amendments that you raise, and those go to the heart of the argument that the law could lead to racial profiling. Is that not correct?
Well, it is correct. The 14th in particular. The Fourth Amendment, which we feel is very strong, the judge indicated that she felt that our arguments on Fourth Amendment grounds, specifically unreasonable seizures, and that this law will inevitably lead to detaining people for longer than is allowed under our Constitution, longer than the suspicion or cause would permit, because of keeping people to get their status settled before they're released, and a number of other provisions. Judge Bolton indicated in her earlier decision that we had made strong arguments. She didn't have to rule on them because the provision was being enjoined based on preemption. But we believe that the Fourth Amendment's prohibition on unreasonable seizures will lead to enjoining a number of the provisions in this particular law. And secondly, as you mentioned, the Equal Protection Clause of the 14th Amendment, we believe will be inevitably and violated in a widespread manner. That is because of the racial profiling, that the law will lead to decisions being made based solely on the race and ethnicity of the targeted population, because as we've seen in Maricopa County as the prime example, and we mentioned this in our complaint in the Friendly House case, Mr. Arpaio has indicated, I didn't need 1070, I've been doing that already. That means, as we have seen in practice, racial profiling, selecting people solely on the basis of race, seeing if you can draw as wide a net as possible on brown-skinned people, and then sorting them out after, turning the presumption of innocence on his head has been his M.O. In order to up his numbers that he can boast about for immigration enforcement, and this law will inevitably lead to the same results.
We will have ongoing coverage of the SB 1070 decision all week. It will culminate in a live online town hall in a partnership with Washington Week this Friday from 5:30 to 6 in the evening at azpm.org. Coming up tomorrow night, we'll address the economy and local businesses that are having to make adjustments for the construction of Tucson streetcar. Also, you'll learn about some of the history of the Temple of Music and Art. I'm Tony Paniagua. From all of us at Arizona Public Media, have a great night.